Hi everyone, welcome to the GoldFish Report. I'm your host, Louisa. Today is Wednesday, November 14th, 2018, and this is a new platform, a new type of program that GoldFish Report is doing. It's called Bullet Points. And each week we'll focus on another topic, usually of policy, but probably could be a world event as well or something else that's going on. But it's probably going to focus mostly on policy. Uh, this week, and I also wanted to thank our viewers who are contributing to our Road to the White House fund drive. We can't do it without you. We have been to the White House reporting, and we're very grateful that President Trump has welcomed social media and other forms of media because he's very open to free press. So, but respectful press. I think I should probably underscore that. So we have been there and we are grateful, but it's expensive, folks. So without your support, we can't get there and do these reports and bring this information to you. The GoldFish Report also posts the latest press secretary press releases. So you'll find those on the GoldFish Report. Those include all kinds of information regarding the president. So that's primarily what we focus on, our issues. As you know, for 95 weeks, we've been doing a POTUS report. So this is kind of like an extension of our POTUS reports, but we really focus on certain topics to cover. This week, we're going to focus on immigration. Well, the topic is presidential powers, but the focus is on immigration. And what does the president really have in terms of what powers does the president have in terms of actually making decisions on immigration? And we're going to review that. First, we're going to it's really kind of like a quick academic review of what the history has been with immigration. So that's going to be very brief. And of course, where we are right now, what the president, what other presidents have done, just briefly as well, just to give us an idea of what's happening and what the issues are that they're really going to be discussing in terms of dealing with these immigrants, this mass caravan or invasion, in fact, that's heading towards our border. And I believe, as of reports today, there are people showing up already, and so the president has taken action, and we're going to talk about that. So what I'm going to do is I'm going to screen share a PowerPoint, and I hope it doesn't become boring to people, but we'll find out. I guess you'll let me know, won't you? So here's our a presentation here. And so I'm going to go through the slideshow. We're calling this bullet points, as I said, and today's topic is, as I mentioned already, presidential powers, which we will probably talk about a lot, since, as our viewers know, my graduate work was on focusing on the president and the media, and hopefully I'll be resuming that soon. But this focus is on immigration today. So this is basically a brief historical perspective on immigration. We can see, I think this slideshow is it's moving on its own. Jeez. Okay, got to go back. This is Ellis Island. This is what it looked like when we were first going through more mass immigration in the United States, which everybody knows. You can always go to Ellis Island and visit there. And this is near and dear to many of our hearts, because if it wasn't for this immigration at Ellis Island, many of us would not be here, myself included. So this has always been a staple of America. But there was an orderly way. These people came in legally, and they waited. Obviously, you could see they had to be subjected to examination, as you could see right here. Many waited, and they waited. They weren't rioting. Look at them. They're standing there with suitcases. They were, respectful. And this is our history. This is the historical way that we have done immigration. So what we're going to just take a look is a real quick look at this history. And we'll start at 1790, the Naturalization Act. And of course, The slideshow's doing this again. I'll have to get it. Hang on this. It excluded non-white people from eligibility to naturalize. Naturalization requirements included 2 years of residence in the country and good moral character. And an applicant must be a free white person. So obviously there weren't free white people then too. The Naturalization Act of 1795 extended the residency requirement to 5 years, and in 1798 this was extended to 14 years, then back to 5 in 1802. In 1790, law was the first to specify who could become a citizen, limiting that privilege to free whites of good moral character, which I just mentioned, who had lived in the U.S. for at least 2 years. And in 1870, the right of citizenship was extended to those of African origin. Starting in 1875, a series of restrictions on immigration were enacted. They included bans on criminals, people caught with contagious diseases, polygamists, anarchists, beggars, and importers of prostitutes. Other restrictions targeted the rising number of Asian immigrants, first limiting migration from China and later banning immigration from most Asian countries. Laws were passed in 1921 and 24 to try to restore earlier immigration patterns by capping total annual immigration and imposing numerical quotas based on immigrant nationality that favored Northern and Western European countries. However, in 1952, legislation allowed a limited number of visas for other Asians, and race was formally removed as grounds for exclusion. In 1965, though, a combination of political, social, and geopolitical factors led to the passage of the landmark Immigration and Nationality Act that created a new system favoring family reunification and skilled immigrants rather than country quotas. Some people refer to it as the Act of 1952. Excuse me. It's referred to as the McCarran-Walter Act. So we're going to start from there, okay? Moving forward, 1990 law created temporary protective status that has shielded immigrants, mainly Central Americans, from deportation to countries facing natural disasters, armed conflicts, or other extraordinary conditions. In 1986, Congress enacted another major law, the Immigration Reform and Control Act, that granted legalization to millions of unauthorized immigrants, mainly from Latin America, who met certain conditions. The law also imposed sanctions on employers who hired unauthorized immigrants. Subsequent laws in 1996, 2002, and 2006 were responses to concerns about terrorism and unauthorized immigration. These measures emphasized border control, prioritized enforcement of laws on hiring immigrants, and tightened admissions eligibility. In 2012, President Obama took executive action to allow young adults who had been brought to the country illegally to apply for deportation relief and a work permit. And we're going to talk more about this precedent that other presidents have taken as well towards the end of this these bullet points. In 2014, President Obama expanded that program known as Deferred Action for Childhood Arrivals, or Daca, and set up a new program to offer similar benefits to some unauthorized immigrant parents of U.S.-born children. The DACA expansion and the new program, Deferred Actions for Parents of Americans and Lawful Permanent Residents, or DAPA, are on hold because of a legal challenge by 26 states. So what we're dealing with today is, since President Trump took office, we have, in terms of immigration and presidential powers, we have President Trump's executive order 13769, titled Protecting the Nation from Foreign Terrorist Entry into the United States. And this section here is referencing the Federal Register, Volume 82, Number 20, Wednesday, February 1st, 2017. And it states, by the authority vested in me as president, by the Constitution and the laws of the United States of America, including the Immigration and Nationality Act, which we just talked about. So he cites this 1952 act as where he derives his power from for making this executive order. And Section 301 of Title III, United States Code, and to protect the American people from terrorist attacks by foreign nationals admitted to the United States. So just briefly, Section 1, there's a purpose. It talks about the visa issuance process, plays a crucial role in detecting individuals with terrorist ties and stopping them from entering the U.S. Section 2 is policy. It's the policy of the United States to protect its citizens from foreign nationals who intend to commit terrorist attacks in the United States, and to prevent the admission of foreign nationals who intend to exploit United States immigration laws for malevolent purposes. Section 3 talks about the suspension of issuances of visas and other immigration benefits to nationals of countries of particular concern. And that's going to be very important when we talk about the proclamation later that President Trump just recently issued. Section 4, implementing uniform screening standards for all immigration programs. Section 5, these are just the basic sections that it consisted of. I'm not going to go into the detail. I'm going to cite these sources in the description section of the video. So if any of the viewers want to go take a look at it for themselves, it's available for you to do that. But in this short bullet point, I'm not going to go into all the details. Section 5 is a realignment of the U.S. refugee admission program for fiscal year 2017. As you can see, it also refers to Section 6, rescission of exercise of authority relating to the terrorist grounds of inadmissibility. Section 7, expedited completion of the biometric entry-exit tracking system. Now, this is interesting, folks. Biometric. So we're talking fingerprints, we're talking handprints, and perhaps we're talking, who knows, iris scans and retina scans and things of that nature as well. So Section 8 is visa interview security, which, that's part of the process. Section 9, visa validity, reciprocity. Section 10, transparency, and so forth. So this is basically what it states. And again, this executive order, as I mentioned, the president derives his presidential authority to issue this executive order by the invocation of Section 212F of the 1952 law, Immigration and Nationality Act, which states, this is a statute from that law that reads, whenever the president finds that the entry of any aliens or of any class of aliens into the United States would be detrimental to the interests of the United States, he may by proclamation and for such period as he shall deem necessary, suspend the entry of all aliens or any class of aliens as immigrants or non-immigrants, or impose on the entry of aliens any restrictions he may deem to be appropriate. Whenever the Attorney General finds that a commercial airline has failed to comply with regulations of the Attorney General relating to the requirements of airlines for the detection of fraudulent documents used by passengers traveling to the United States, including the training of personnel in such detection, the Attorney General may suspend the entry of some or all aliens transported to the United States by such airline. So this section here basically has two parts. So the first explains the president's power to issue the proclamation, and the second refers to the Attorney General's power to prevent entry of aliens traveling by airlines. So this is, in a nutshell, this is where he cited, this is where President Trump cited this, and this is what now we're talking about the proclamation. So that was the executive order. And just recently, this week, President Trump issued a proclamation called Presidential Proclamation Addressing Mass Migration Through the Southern Border of the United States. The excerpts here, it says, I, Donald Trump, by the authority vested in me by the Constitution and the laws of the United States, including sections 212F and 215A of the Immigration and Nationality Act, which we just cited, which we just talked about, hereby find that absent the measures set forth in this proclamation, the entry into the United States of persons described in Section 1 of this proclamation would be detrimental to the interests of the United States, and their entry should be subject to certain restrictions, limitations, and exceptions. So I hereby proclaim the following. Section 1, it refers to a suspension and limitation on entry. So this is the entry of any alien into the United States across the international boundary between the United States and Mexico is hereby suspended and limited, subject to Section 2 of this proclamation. That suspension and limitation shall expire 90 days after the date of this proclamation, or the date on which an agreement permits the United States to remove aliens to Mexico in compliance with the terms of Section 208 of the INA, whichever is earlier. The INA is that law that we just cited. Here's Section 2. Scope and implementation of suspension and limitation on entry. The suspension and limitation on entry pursuant to Section 1 of this proclamation shall apply only to aliens who enter the United States after the date of this proclamation. So it is not retroactive. The suspension and limitation on entry pursuant to Section 1 of this proclamation shall not apply to any alien who enters the United States at port of entry or properly presents for inspection, or to any lawful permanent resident of the United States. So here they're really focusing on going to, doing this legally. Okay, if you want to seek asylum, if you want to immigrate, you need to go through the normal ports of entry, and which is our legal protocol. It's how and this is what the president is trying to encourage people to do. We'll talk about that a little bit more. But here, Section C says, nothing in this proclamation shall limit an alien entering the United States from being considered for withholding of removal under Section 241 of the INA. So this INA is a huge law. This is the main body that the president is relying on which gave him the power to make these proclamations, where he's citing his power and authority to do so. Or protection pursuant to the regulations promulgated under the authority of the implementing legislation regarding the Convention Against Torture and other, I went too quick there, torture and other cruel, inhumane, or degrading treatment or punishment, or limit the statutory process afforded to unaccompanied alien children upon entering the United States under the Code Section 279, Title 6. Okay, so you can look this up and get the details on it. And of course, Section D of this proclamation says no later than 90 days after the date of this proclamation, the Secretary of State, the Attorney General, and the Secretary of Homeland Security shall jointly submit to the President, through the Assistant to the President for National Security Affairs, the NSA, a recommendation on whether an extension or renewal of this suspension or limitation on entry in Section 1 of this proclamation is in the interest of the United States. So here they're saying they have upon review, and that there's a process that the NSA is going to make recommendations to the AG and the Secretary of Homeland Security as to whether they should extend this 90-day limitation and ban. So here, hold on a second. Sorry, it went a little bit quick. So here it tells you this: the Secretary of State and the Secretary of Homeland Security shall consult with the government of Mexico as well regarding appropriate steps consistent with applicable law and the foreign policy, national security, and public safety interests of the United States to address the approach of large groups of aliens traveling through Mexico with the intent of entering the United States unlawfully, including efforts to deter, dissuade, and return such aliens before they physically enter the United States territory through the southern border. So here the president is saying, I'm giving the Secretary of State, Secretary of Homeland Security, the power and the authority to consult with the government of Mexico regarding these large groups of their population that are coming to our borders. So, here the president is trying to, this is a very diplomatic solution as well. So this is kind of, this is very interesting. I think this is an interesting addition to have this diplomatic solution in there as well, when there's large, large numbers of people from a particular region who want to immigrate or want to seek asylum, or at least claim they want to seek asylum. But we're going to talk about this. What is this process? What qualifies people for asylum? It says to be granted asylum, applicants must meet 3 requirements laid out by the UN Convention on Refugees in 1951 and adopted by the United States applicants. must prove, one, they have a reasonable fear of persecution in their home country. Reasonable fear is defined by the United Nations as at least a 10% chance of persecution. Two, they must fear persecution of one of 5 grounds: race, religion, nationality, political opinion, or membership in a particular social class. The most amorphous of the 5 categories. It can include things like sexuality or caste. And the third is they must prove the government of their home country is either involved in the persecution or unable to control it. And I think in all fairness, I think, that these standards are set, as it says, by the UN Convention. So this refers to pretty much anybody seeking asylum in any country. Now, citing this 1952 INA, Title II Immigration, Chapter 1, Selection System, conditions for granting asylum. So here you have an explanation of the eligibility. The Secretary of Homeland Security or the Attorney General may grant asylum to an alien who has applied for asylum in accordance with the requirements and procedures established by the Secretary of Homeland Security, blah, 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 which we already know. And here is the citation for that. In general, the burden of proof is on the applicant to establish that the applicant is a refugee within the meaning of this section here. To establish that the applicant is a refugee within the meaning of such section, the applicant must establish that race, religion, nationality, membership in a particular social group, or political opinion was or will be at least one central reason for persecuting the applicant. Okay, so there's definitely a burden of proof and standard here that has to be reached. Here's the burden of proof, sustaining burden. The testimony of the applicant may be sufficient to sustain the applicant's burden without corroboration, or only if the applicant satisfies the trier of fact that the applicant's testimony is credible, is persuasive, and refers to specific facts sufficient to demonstrate that the application is a refugee. In determining whether the applicant has met the applicant's burden, the trier of fact may weigh the credible testimony along with other evidence of record. Where the trier of fact determines that the applicant should provide evidence that corroborates otherwise credible testimony, such evidence must be provided unless the applicant does not have the evidence and cannot reasonably obtain the evidence. So here we have credibility determination, which you can pause this and read this for yourself, but there's definitely a determination that's made on the credibility of those statements, so you can read that. And I'm just trying to show that there's a process that everybody has to go through and everybody has to meet. And from what I understood, the statistics that I saw, anywhere between a third and a fourth of people who apply for asylum are not granted asylum, that they don't actually meet the criteria. Or, as you'll see soon, that there is a very large list of exemptions of people who can even apply for asylum, especially if you've been convicted of crimes or if you've been smuggling drugs or human trafficking, things of that nature. So here we have consideration of asylum applications. This is still under Chapter 1, under selection system. Are these procedures established under the paragraph 1 that provide asylum cannot be granted until the identity of the applicant has been checked against all appropriate records or databases maintained by the Attorney General and by the Secretary of State, including the automated visa lookout system, to determine any grounds on which the alien may be inadmissible to or deportable from the United States or ineligible to apply for or be granted asylum. And there's a very long list, I have to say, and there's many subsections to that. And I'm going to go into some of that, but I'm going to provide those links basically to this. I'm going to provide the link to this law. And you can look at all the subsections yourself if you really want to understand this. But it's part of our history. And I thought it was confusing, actually. And I thought, that I wanted to do this little summary to try to make this, to try to clarify it's a very complicated process. There's attorneys and law firms that specialize, as you know, in just immigration law. So, and this is not legal advice. I am not giving legal advice, and I am not an authority on this. As I have said, this is basically a brief academic review, just for information and education purposes only. Okay, and again here, this is the section that I was citing just now, general classes of deportable aliens. So you can go and look this up on the link that I'm going to provide, and it's a very long one, which is why I didn't include any of them in this, because it was very, very long, other than the ones that I just verbally mentioned. Now the precedent of past presidential power on barring immigration under using the same Section 212. We have President Trump is not the first president to make use of Section 212 after 1965. In 1981, President Ronald Reagan used it to bar any undocumented aliens arriving at the borders of the United States from the high seas. While in 1986, he used it to bar Cuban nationals, with some exceptions. In 1994, Bill Clinton used it to bar anyone in the Haitian military or government affiliated with the 1991 coup d'etat that overthrew the democratically elected president. 10 years later, George W. Bush used it to bar corrupt members of the government of Zimbabwe from entering the U.S., and in 2012, Barack Obama used it to bar hackers aiding Iran and Syria. So there is precedent here. President Trump's not the first one, but boy, this is the first time I remember hearing this kind of, pushback and attack against the president for doing this to this degree. Also, President Trump appears to be the first president to apply a blanket ban to everyone from a specific country, more than one in this case, since President Jimmy Carter used this provision to keep out Iranians during the Iran hostage crisis. So it has been used before. President Trump's not the first one, but he's the first since Jimmy Carter had used it, President Jimmy Carter. And of course, there have been previous challenges, judicial challenges to these actions, and we're going to just review a couple of them. The language of Section 212 appears to vest the president with very broad authority to suspend or restrict immigration of aliens or of a class of aliens by presidential proclamation, which we discussed. In limited case law, courts have thus far not identified or defined any limits on the president's Section 212 authority. This is a matter of fact, folks. The Supreme Court addressed Section 212 once in Sale versus Haitian Centers Council, Inc. Sale concerned Executive Order 12800, wherein President George Bush ordered the suspension of entry for aliens coming to the United States by sea without proper documentation, and for the interdiction of certain vessels carrying such aliens. The Supreme Court held that the executive order issued on the basis of Section 212F, as well as other provisions, did not violate the INA's provision for withholding of removal or the United States obligation under the United Nations Convention relating to status of refugees applied to actions taken by the Coast Guard on high seas in enforcing the executive order. In Haitian Refugee Center, Inc. versus Baker, the 11th Circuit issued a decision addressing President Ronald Reagan's Executive Order 12324, which also concerned the suspension of entry of aliens coming to the United States by sea without proper documentation. In this decision, the 11th Circuit held that aliens who had been interdicted on the high seas under executive order had no right to judicial or administrative review. Regarding the scope of Section 212F itself, the 11th Circuit stated that it clearly grants the president broad discretionary authority to control the entry of aliens into the United States. And I can tell you they're going to have a very difficult time trying to challenge the president on this. And of course, the Supreme Court, I'm not a Supreme Court judge, but we do have some case law here that's very clear on how the Supreme Court has ruled on these issues in the past. So it'll be very interesting, I think, in the end, to see what the Supreme Court will do to any challenge to this executive order or the proclamation by President Trump. In a footnote to the DC Circuit decision and Borsk versus Reagan, the court stated that Section 212F ensures that the executive would not be helpless in the face of such a threat of an alien who posed a danger to the United States, but was not excludable under the statutory scheme that existed. Whoops, that's my finger. Trigger finger, sorry. Under the statutory scheme that existed at the time. The footnote continued, stating that the president's sweeping proclamation power thus provides a safeguard against the danger posed by any particular case or class of cases that is not covered by one of the categories in the old Section 212. Interestingly, these footnotes were penned by then Judge Ruth Bader Ginsburg, who is now, of course, a justice who is going to be stepping down and retiring in January, I believe, January of 2019. So that's very interesting. That's going to be, an issue. The Supreme Court's going to, this has been decided already, folks. Okay, so also in Mao Sung Wong versus Campbell, the Ninth Circuit held that the president's authority to issue an executive order preventing an alien from taking the examination for or giving an appointment in civil service is derived from his powers over foreign affairs and treaty obligations rather than from congressional delegation. However, the Ninth Circuit cited to Section 212F as an example of where Congress delegated authority to the president. So here, this one is saying the president also has powers to do this under foreign affairs and treaty obligations, which is cited in this law, by the way. So it's, and then of course citing the 212 example again, where Congress delegated that authority to the president. And of course in 1950, the Supreme Court in U.S. ex rel. Knopf versus Shaughnessy held with regard to a pre-INA statutory scheme that contained similar provisions that there is no question of inappropriate delegation of legislative power involved here. The exclusion of aliens is a fundamental act of sovereignty. The right to do so stems not alone from legislative power, but is inherent in the executive power to control the foreign affairs of the nation. That went off by itself, sorry. This passage was cited by the U.S. District Court for the Northern District of California in this cited case. So this is it in a nutshell. I wanted to just kind of briefly give a little history and a little precedence as to what where the president came from. It is completely legitimate. He has complete authority to act and to cite the law that he did, as there have been judicial challenges to this in the past, which we just saw, which gave the, that ruled on the side of the president for doing this. So, I mean, certainly there could be people who don't like it, but this has been, as we showed through historically, there have been changes to immigration. We do that through the law process. As you know, this proclamation has to be reviewed, and after 90 days, a decision made whether to continue to extend that. So I think that, it's one thing for people to want to control a narrative of what's happening politically. This became a political football, and these are very complicated topics, which is why I wanted to do this brief academic review so people had a little bit of background as to what, where our history has come from in terms of immigration. And of course, where the president, has come from in terms of where he gets his authority to make these, proclamations and executive orders. This way you can have an intelligent conversation on the topic, even if it's just a brief information. You at least have this 1952, it's called the McCarran-Walter Act. And this is what's been cited over and over and over again, not just by President Trump, by other presidents, and also by previous circuit court and Supreme Court judge. So you have it right there. The president's in full authority in doing this, and to argue this, and I think that President Trump was right in that press conference that I attended last week, where you had Jim Acosta from CNN, challenging the president on even qualifying it as an invasion was not his position to do that. The president appropriately said, you know, leave running the country up to me and you run CNN, whatever. Now there's a lawsuit, and everybody knows there's a lawsuit now. The CNN and Jim Acosta are going to sue the president for revoking his credentials. And that's a whole other issue, which I'm not going to get into, but that was the issue that caused that to happen. Or at least that was the issue that they got into this little, I would say, a scrimmage about. And, you know, President Trump is not one to shy from scrimmage, but you know, be respectful about it and know your place and your role when you're trying to address the president, and have respect for the office of the presidency. And so I put this together to give the viewers an idea of what's involved in this issue. And they're extremely complicated issues. I mean, the laws, you know, all these exclusions, there's a long list of exclusions. It's very complicated. But I will put the listings, I will put the all the resources in here and the citations in this report, and I hope you benefit from it. And I just want to remind our viewers one more time that, you know, if you want to support the GoldFish Report and you want to become a patron, which we need in order to keep this going, you can go to the goldfishreport.com. There's a PayPal page there. I'm sorry, there's a PayPal link there, and there's also a link to our Patreon site page, so you can become a Patreon. So this is going to be a new series that we do called Bullet Points, as you can see through the bullet points of the PowerPoint presentation. So we try to keep it concise. This one is very complicated, so this one might be a little bit longer than I think future bullet point reports may be. But I wanted to bring this up, and you know, by all means, anyone has any comments about this, if you want to continue this dialogue, let me know, because in future bullet points we might do it live and have, you know, some interaction with our viewers on that. And I welcome that, and I really would enjoy that. And also make your comments if you want to. If you have anything you want to add to this, put it in the comment section. But please be respectful, because we're being respectful in bringing this information to you, and we're doing it for the viewer. Because I know a lot of people really became disgusted with politics and stopped following this, and stopped educating themselves, stopped informing themselves. And when you do that, then you have, I mean, if no one watching the store, then you have, crimes of opportunity that can happen. And I think we're going to be seeing this coming out of the next few days. So folks, I hope you enjoyed this short review of policy. And we're not sure quite yet if we're going to make it to the White House next week. We don't have enough in our fund drive to do that. We need at least $1,000 to $1,200, folks, to do it for the week. So if you can contribute, please do, to keep these reports going and to keep reporting from the White House. And we just continue to do this as a service to the public. So thank you for viewing. And this concludes this edition of the GoldFish Report.